Good afternoon, and thank you for joining us today. I would like to welcome you to the FortneyScott webinar entitled Managing DEI Under Trump's Executive Orders. This webinar will be recorded. All listeners' phones are muted. Today's presenters are FortneyScott attorneys David Fortney, Elizabeth Bradley, and Nita Beecher. I will now turn the program over to David Fortney to start the webinar.
Great. Sarah, thank you so much. And hi, everyone. We're so glad to have so many of you with us today. These developments continue to feel almost overwhelming, to be honest. So let me just shout out because you can only see the person who's speaking. Liz, why don't you say hi? Are you with us?
I am sorry, I was on the mute button there. So welcome, everybody. Thank you for joining us. We look forward to this discussion.
Nita, how are we doing today?
We are just barreling forward and feeling very overwhelmed right now.
Yeah, we I think all have a bit of a sleep deprivation. Well, let's jump right in and try to take good advantage of all of your time. Just a brief mention as to who we are as a firm. I think most of you joining today do know. And Sarah, if you could just jump to the next slide for us, please. Of course, we're based in Washington, D.C. We do represent and counsel a broad range of employers and federal contractors. And candidly, we deal with exactly the type of stuff that we're going to be discussing today, which is federal contracting, employer obligations, and in today's session, really bearing down on the new DEI obligations. We have been doing a lot of this with many, many contractors. Let me just take a moment and give you an overview of what we hope to cover. Obviously, the banner headline is the attack on DEI. This commenced with President Trump's a series of executive orders. We're going to unpack those a bit and review those just to make sure. I think most of you are generally familiar. We're going to give you some highlights on that. Then we want to really bear down on the DEI programs. What do you do in response to these executive orders? I mean, that is the question that we are spending so much time with our clients trying to answer. We know that so many employers, contractors are struggling with that. People that have spent years developing DEI programs, almost all of which are legally sound, but is there potentially a problem here? Those are the practical questions we're going to try to unpack. And then we do want to try to leave you with some practical next steps based on our experience, how we see the lay of the land. So let's begin with, why do we have the problem? What is the attack on DEI? And Liz, maybe I can ask you to lead that off.
Absolutely. So before we can talk about how to measure our DEI programs under Trump, we need to be looking at what his executive orders have been and how they are attacking DE&I programs. Not a small list we have in front of us of the executive orders that have come out since Trump came into office. And not all of these, looking at some of these, you're like, well, what do the executive order of America's Fighting Force, for example, how does that impact private employers? And we're going to talk through a few of the sort of, I call them the Easter eggs or the little nuggets that we are seeing that is sprinkled in various different executive orders that is aiming at and targeting DE&I. And just want to highlight, obviously, the executive order ending illegal discrimination and restoring merit-based opportunities, which we covered in our prior webinar and also a podcast, is where we're going to kind of start this discussion, and it's the foundation of the attack on DE&I. And I'm going to hand it over to Nita to kind of go into some of those more specific provisions.
Thanks, Liz. I really appreciate it. So you all went into great detail about this executive order, which has now got a number, 14137. Doesn't roll off the tongue like 11246 did. But there are two aspects of this. In addition to basically rescinding Executive Order 11246, there are two aspects that we want to talk about, which will really be the remainder of our conversation. Section 3 talks about federal contractors are going to have a new certification, and that's one that's material under the False Claims Act that a contractor does not operate any programs promoting DE&I that violate any applicable federal anti-discrimination laws. So it's a much broader requirement than what we had where we certify with the OFCCP. The second part of this, which applies to all employers, is Section 4, which encourages the end of illegal DE&I by requiring agencies and the Attorney General to submit reports to Stephen Miller, who's the Deputy Chief of Staff, by May 21st on the most egregious and discriminatory DE&I practitioners, and each agency is to identify 9 potential entities, including public corporations and higher education institutions, for federal litigation. And I believe, David, you said last time there are some 435 or 436 agencies. So that's a lot of corporations right there.
That's
It's
right.
worth note. Oh,
I was just going to say
sorry.
that's right, because this is something that I think many people saw that number 9 and think there's only going to be 9 companies that get called out. No, as a practical matter, there are potentially thousands of companies that can be called out. And the 9 may be the most egregious, but that doesn't limit the number either. So I think that many people, these 2 provisions, and our previous materials have really covered these in detail. But I think as the employer and the federal contractor communities become more familiar with this, are recognizing these are both individually quite alarming meaning that they up the ante on compliance very dramatically in ways we haven't seen. Sorry, Liz, I didn't mean to step on you there.
Well, to that point about upping the ante, I think it's worth noting that earlier this week, litigation was filed challenging these 2 provisions. So that is pending and just been filed on Monday of this week, challenging it over, saying it's having a chilling effect on free speech. So we will see how that rolls out.
One last thing I wanted to say before we move on is that the False Claims Act has these provisions where you can have whistleblowers who call into the government and say, oh, my employer has, I'm a federal contractor. They made me take this DE&I training and it violates the president's executive order, and they get money, lots and lots of money. So this is a big deal.
And can I just quantify, Nita, while we go to the next slide? To put it in context, the whistleblower data that's published on the Justice Department website indicates that in fiscal year 24, $2.9 billion was collected under this program, and 2.5 were from individual whistleblowers, what are called relators under this bringing key TAM action. So the power of the individual, this new powered up enforcement scheme, is very significant.
Now, Liz previously wanted us to point out to you some of these Easter eggs. Here's one. So in the Restoring America's Fighting Force, you have a definition of what a DE&I office is. We don't have that in the other executive order, but here it's an institution, a unit of an institution influencing hiring or employment practices with respect to race, sex, color, and ethnicity, other than through the use of colorblind or sex-neutral hiring processes, or promoting differential treatment of or providing special benefits to individuals based on race, sex, color, or ethnicity. These are important as we talk about your DE&I practices a little bit later on.
It's also important about the context, the definition of a DE&I office, and the word illegal is not included here. The perspective of this administration is a DE&I office is by definition giving preferential treatment and engaging in conduct that it finds unlawful. So I think there's just understanding the viewpoint and the vantage point that all of your programs are going to be viewed from is very telling here.
What's difficult, I think, Liz and David, for federal contractors is they have always thought about looking at hiring and promotion and so forth with an eye towards race and gender, not as quotas or anything like that, but to be conscious are we, do we have goals? Do we, are we underutilized and all that type of thing? And so this is going to be a big change for them.
Absolutely.
We have one more, and this one's important because when we'll talk about this, this has to do with what they call the radical indoctrination, ending the radical indoctrination of K through 12. And here, this is some of the, we've seen some training in DE&I, which talks about whether a sex, race, or ethnicity is morally or inherently superior, whether it's racist, sexist, and so forth. Some of this, I think we've talked about, some of this came out of the 1619 project, which talked about the inherently racist our origins of the United States. And so I think a lot of people have a lot of training materials which may fall within some of these requirements.
Yeah, I think that these materials are useful to help inform, because the bare bone executive order that directly applies to employers and federal contractors that we've talked extensively about doesn't build these terms out. But what we have seen, and what Liz has really done a nice job in helping to assemble these examples, and there are others, is there is a whole fairly robust description. It's one that's quite at odds with how anyone in the DEI community or the compliance community has traditionally thought about DEI. And that's kind of the key takeaway here, I think, is for us to realize, without debating whether it's a good philosophy, whether it's legally compliant, and not getting into all that, this is where the Trump administration is coming from in through these executive orders. When they talk about DEI, this isn't, as they used to say, this isn't your grandfather's Republican Party anymore. This isn't your grandfather's DEI program anymore either. It is defined very aggressively and in a very restrictive manner.
So
Well,
David, what do we have? What is the framework
I
that
was
we
going to say,
have?
so that feels like doomy and gloomy, and
Yeah.
but let me just remind everyone, as we're 2.5 weeks into the administration, other than, and I don't mean to minimize that, the rescission of Executive Order 11246, nothing in the EEO legal landscape has changed. The statute has not been modified, rescinded, or amended. And that cannot occur unilaterally. I don't care how many executive orders President Trump issues or other directives that come from the White House. So we do know that the legal baseline is exactly what is prescribed by Title VII. I think everyone is very, very familiar with what these standards are. It defines what is an unlawful employment practice. And these are ones that have been these requirements have been the foundational elements of any well-designed DEI program. So the question is, and what we need to keep in mind is, okay, if it passes legal muster, is that going to be good enough? And legal muster is Title VII with the benefit of the Supreme Court, and I include Bostock and Muldrow and some of the more recent decisions that have given a more expansive reading of Title VII. I would suggest perhaps more expansive than the current administration would like if it could define it itself, but of course it cannot. The law is the law, as they say, and that's where it stands. So this slide is really just a reminder on, kind of basic principles on what's there. I'll just jump off on this one, then folks comment as you wish.
Sure.
Of course, we all know that the commission does not have a quorum, but the acting chair, Andrea Lucas, has issued several public statements about kind of subject to, and there are some restrictions on what she can do without a quorum. And she cannot revise the harassment guidance or other strategic documents. But there's a lot that the chair can do. The chair is although a commissioner, wields a lot of authority and has a lot of autonomy in what is done. So through exercising her authority as the acting chair Lucas has announced her priorities to defend biological and the binary reality of sex. That's her language. And she is expressly embraced the president's executive orders that so defined based on characteristics, sex characteristics at birth. She has removed the agency pronoun app. This is they, them, or selecting which pronoun you want gone. Ended the use of the X gender marker during intake and processing. And I might add, this is across the board. Anyone who's applying for a passport, any other federal documentation, the X gender marker that has been introduced over the last couple of years has effectively been erased, and that's effective immediately. That has occurred. And the reference to any gender ideology from both their internal and external website. So it is really the acting chair's attempt to reconfigure the EEOC, and there's some information that perhaps certain pending investigations are also correspondingly being reconfigured along these lines. But that is a change, and I think that's important that we recognize that. Liz or Nita, anything you want to add on the EEOC front?
And I think it's going to be a little bit, I think we know where their enforcement is going to go, which also then looks at some of the priorities that employers need to be focusing on when they are analyzing and assessing their DE&I programs.
That's
Yeah.
a really good point. And I think the one thing to remember is that sexual orientation and gender identity is still protected until Bostock is overturned by the Supreme Court or Congress passes something that says they're not protected. And it's really only the more extended version of Bostock that she is attacking, to be honest.
That is correct.
Good
And
point.
indeed, I actually reread Bostock in the light of these developments over the last week. And I had forgotten, but the opinion does note that they are not addressing things like change facilities or bathrooms or so
Right.
forth. So those issues were left open. And so there is arguably running room for this administration to take a 180 from the view that had been adopted by the prior administration. And I think that the acting chair is going to do that within her authority. So DEI, not Liz, got anything else?
Nope, I'm
No?
good.
Okay, good. To make sure. So let me just round off with, of course, President Trump himself has led the assault on DEI. And in his initial explanation as to the tragedy at National Airport last week, which was just horrific, he expressly, after taking a moment or two of silence, turned immediately to indicate that DEI was at the heart of it. I will not repeat or in any way try to summarize that. If you're interested, you can Google it and find it for yourself. I think most of us did find it deeply offensive, not factually grounded. But why is this important? This is important because it is signaling. This is the MO, as we understand it from the administration. DEI is bad. It is bad and it must be eliminated. Full stop. There's not a lot of legal parsing that goes on from this viewpoint. It's so bad, it's causing the airplanes to fall from the sky. The week before, it caused the fires in California to burn the way they did, etc. This is a very concerted, deliberate effort to degrade and misexplain and misstate DEI. And I state that so that we all recognize that is the mindset of the president himself, who has led many of these points. And I think that's fair to say that particularly in this administration, we can expect most of his agencies to do their best to try to align with that mindset. So on that less than happy note, let's talk about what that means, because we've got the executive orders that say no illegal DEI. We've got a pretty broad brush on what is DEI or bad DEI. Liz, maybe you can open up this session.
Right. So we're not saying, and I'm going to take you a little bit out of the doom and gloom there. We're not saying all of your programs need to go away, but you need to be doing a review of those programs because we understand, in light of the potential risks, we want to start assessing your existing DE&I programs to determine which ones can safely move forward. And when we're looking at these, first of all, want to say this work should be done under the attorney-client privilege. There are a lot of protections, not just, yes, the legal protections are, but you get in a room, you want to have open conversations, open dialogues about what your programs are, what you want to be able to achieve, how your programs are actually running, what your concerns are. Having these conversations protected by the attorney-client privilege protects them from being disclosed when a plaintiff's action or an investigation comes in and they ask, why did you change this program or that program? Those underlying conversations, those working sessions are not going to be subject to disclosure. So it's really important to have the protection built around those communications. You also need to make sure all of the key stakeholders are involved in these discussions, not just led by HR or whoever is currently running your DE&I programs. You're going to need to have, are there compensation programs? Are there outreach, recruitment? And you need to have the leaders, the individuals who lead those programs and run those programs sitting at the table with you. So you're having a holistic conversation and making sure you have across the organization buy-in about what and how you're going to be moving forward. And we're going to be talking about this. Title VII compliance may not be enough. Just because something is lawful, it may end up being a target for this administration. And that's where we're going to kind of get to using a red, yellow, green colored kind of metrics to be looking at these. Red, we're pretty much saying the red or the will be deemed unlawful. Green is completely great, go forward. Yellow is that area where you're going to have to start determining what your risk tolerance level is. Where are your pressure points? External legal, internal employees. And you're going to be developing this pressure point and this color mapping. It needs to be a detailed and holistic review. So don't start with just saying, I've reviewed my policies for DE&I phrasing. You need to actually look into the way the programs are working and what they're doing to see if there's any element in those programs that is a preference for based on race or gender or could be read to be such a program. And those programs need to be cataloged for this deeper review and making a determination about what is going to be moved forward with. You also need to actually look at not just the policies. The policies may be written to be absolutely legally defendable and neutral in practice. What's happening with the boots on the ground? And that's where we often see, and we're going to talk about that in a few of these programs where they can be developed legally, but we often see that they go sideways a little bit when they're actually being implemented. So this is a moment where you need to take pause. And I would say the first thing you need to do is develop that structure before you start going down, catalog your policies, develop the structure. And you need to come into this by setting where are your pressure points? What is your workforce going to tolerate? How much move away from DE&I? And where do you think your pressure points are? Because that's going to help you map your yellows and greens along that spectrum. So once you get this framework together, you start the review. And so I'm going to turn it over to Nita, who's going to start us with a discussion of a few of our reds. What do we
Hey,
think are
Liz,
no-goes? Yes, David.
I'm sorry, can I just have one thing
Of
about
course.
on that initial point, which are public statements that in addition to your internal, I want to make sure that you also touch on external. Some companies through social media have put statements out in the last 12, 24 months. A lot of you are filing your 10Qs, 10Ks. Many of folks we know are doing that by the end of March. There are human capital metrics data that's being filed and that has been filed. So being attentive to Liz's point about getting all the stakeholders, there's a lot of people who touch this. Communications with the board, instructions the board of directors may have given, communications within the leadership team. Obviously, those that handle all the talent management, talent acquisition, compensation, development, all those, this sort of holistic thing, but supply chain, what you're saying to your suppliers, what you're saying to other stakeholders. So I envision this as kind of this 360, very broad, cast your net broadly, to Liz's point, under this privilege point. Then you're going to drill down. The majority of the action is going to be on your workforce related policies, practices, but we don't want you to forget the others around, particularly with these new enforcement tools that are available. They could bring the attention and ire of others.
Yeah. So thank you for that, David. Nita, turning us to the Reds.
Yes, and right before I kick into that, after the Harvard UNC cases came down, we saw exactly what we're starting to roll out. You saw people, whether it was Stephen Miller's group, the America First Legal, which went after woke corporations, or Edward Blum, who had won the Harvard UNC case, also went after a number of these race and gender-based intern fellowship programs. So as Liz was saying, anything where where you are making a decision and you're excluding people based on race or gender, you really need to take a very hard look. Those are very problematic now. And I think it's interesting. I believe earlier this week, Pfizer finally settled a lawsuit that had been brought by Do No Harm, which is another nonprofit, which had alleged they had a fellowship program that discriminated against white and Asian American applicants. I believe it was either Hispanic or Black or both program to bring people into the medical profession. So I think those are ones, so you should go out and look very carefully and see if you have any scholarships, internships, or fellowships that are solely focused on one race or gender. The other thing, I'm sorry, go
Nita,
ahead.
to that point, you mentioned any programs that exclude people based on race. Think about it the other way also. Do you have programs that only include? So don't look at it and say, oh, we haven't excluded anybody. It's just any of those that give a preference and get people added in, even if you're not removing so it's include or exclude based on race or gender
Well,
or
there
any
was
protected class.
there was a good example. Edward Blum went after law firms that had these programs where they brought in only, I believe, either minority, I believe it was minority or underrepresented law students, and they were forced to roll those back or expand who could be applicants to those programs. I think that reinforces what Liz was just saying. The other one we wanted to mention, which is very problematic now, the supplier diversity programs. Many, because there were contracts in the federal contracts, there were obligations to have a certain amount of supplier diversity in your programs. It was a requirement. There were certain percentages depending on your contracts, also known as set-asides. Those have now been overturned. Those contract clauses are no longer valid, so you can't use those as a defense. And David?
Just a quick thought to add on. You mentioned the Harvard UNC litigation, which feels quite long ago, but that's really what kicked this off in so many ways. But many employers and contractors, of course, did a scrub on various DEI programs in response to those decisions, even though we had the argument that was only for student admission and so forth, but nonetheless, they did the scrub. I just would suggest, certainly our experience is, without in any way criticizing those efforts were fine at the time, but I think for the reasons we explained at the top of this webinar, I would not rely solely on, even if you did a pretty thorough review following the Harvard UNC decision on your programs, in light of these new, I'll call them sensitivities or articulated concerns, I would revisit to be sure, because ultimately you, as we've talked about, will have to certify that you are in compliance. And so I think, I do think I would not rely solely on those earlier efforts that were done.
One of the things that happened after the Harvard UNC was there were a number of lawsuits against the Small Business Administration had basically a set aside. There was an assumption that if you were a certain race or gender, you were automatically socially disadvantaged. That has been overturned. And so now you really need to look very hard at your program, and you cannot automatically base your decision making on race or gender. So we have a couple more reds that we'll talk about. So affinity groups is an interesting one. So we are looking at what's going on in the federal government, and there the Defense Intelligence Agency has paused all activities related to Martin Luther King or Black History Month, Juneteenth, LGBTQ Pride Month, Holocaust Remembrance Day, or any of those special observances, which we have been honoring for a number of years now. They've also paused all affinity groups and employee networking groups. Another, the Office of the Director of National Intelligence has curtailed DE&I related boards and working groups, and the Pentagon no longer is permitted to dedicate official resources, including man or person hours, to cultural awareness months.
You know, I look at this list, and this is why it's red, yellow, because it's hard to say that any of those items that have been paused are red legally. They're not red, but we're demonstrating that and informing you that some of the executive branch agencies have deemed them to be red. And putting I think this so synthesizes the conundrum we face. President Trump signs a proclamation declaring we're going to honor Black History Month. Okay, great. That sounds like kind of business as usual. You'd expect any president to do that, not noteworthy. Within 60 minutes of the president signing that executive order, the Department of Defense announces that they will not be honoring Black History Month because it's too divisive, it's too woke, it's too this, dun, dun, dun. So, I mean, literally in the space of an hour, we cannot get a consistent answer. So as an employer and contractor, when you say, well, so is my affinity group program lawful or not? These are the sorts of conundrum, the kind of the factors that we need to think about. I think certainly as a matter of law, they can be, and they generally are. Question as to whether they will attract adverse interest from the administration and what risk you're willing to take.
And I think to that, David, is you need to, this goes to the what is your affinity group program, and then looking at how they're actually operating. This is that deep dive that you need to do into each one of these programs. Are your affinity groups open to everybody? Are there trainings that are only available to women in leadership? Probably problematic. If the affinity group is just putting on a leadership event that anybody can come to and everybody is encouraged to attend, that is not going to be as problematic. So this is that where you have to look at how the program actually operates to do that. Where does it fall on your spectrum of risk?
I think that's really important, Liz, what you're commenting, which is you can't just look at the affinity groups or ERGs and say, well, we don't do, we allow everybody to attend, but you really need to dig in and find out what they're actually doing and how are people going to respond? Because remember, now someone can dial up the Justice Department and say, my employer, ABC Corp, has these affinity groups, and that's an illegal DE&I, and they certified that they didn't have any. And David, I think you're up next.
Yeah, let's talk about surveys. Workforce surveys, an extremely popular and common tool that I actually think most of our clients, I haven't formally surveyed them to to find out, but my sense is that most organizations, in fact, are doing these for a variety of reasons. A lot of it is used to help power up the metrics of your DEI, to demonstrate, to calibrate, what level of participation, where are we on the journey for DEI? And so, and many organizations look well beyond just traditional or more narrow, the legal categories of either the race categories or male, female, and develop additional information. Federal agencies have largely been following that same practice. And again, noting that although this isn't directly binding, it's instructive as to where this administration is coming from, highlighting that 50 employees from Department of Education, which obviously is not a favored department, as we all know, were placed on leave because they analyzed, these are the analysts, these quarterly federal well-being surveys. And well-being surveys are pretty broad. It's like, is your work environment okay? Do you like how you're getting assignments? It's just kind of it's a classic opportunity to hear employees and make sure and to calibrate accordingly. Nonetheless, the folks who were doing the analytics, because they were viewed by the administration as being involved in illegal DEI, have been placed on leave. The EEOC's technical assistance guidance has in fact included conducting anonymous surveys. So once again, we have the left and the right hands going in fairly different direction. Now, admittedly, this is from a time long ago, back in 2017, but they've included conducting anonymous surveys on a regular or a regular survey to assess whether harassment is occurring or perceived to be tolerated. 2017. Let's just remember 2017. Okay, not that long ago. And of course, diversity surveys. Many of our clients conduct lots of diversity surveys. We call out HRC as one, and not that it's good or bad, but we call it out because it is the survey that has attracted significant adverse attention, particularly from Robbie Starbuck. And Mr. Starbuck is not part of this administration, so we're not suggesting that, but I think he does help inform. He is a very vocal critic of various DEI programs, and particularly the HRC survey, which publishes LGBTQ plus scoring and inclusivity and whether the workplace is warm, welcoming, et cetera, for those individuals. And we have many clients that historically have been very proud of being ranked on the HRC survey. They want to be top ranked. They use it as a recruiting tool, et cetera. And they use it within their own workforce to support that. So I think that's something that obviously, these are things that, done properly, they're certainly yellow and I view could be green. However, the administration, I'm not sure, is aligned with that view, which is why we start with yellow. And some of them, at least, we believe may be scored as red by the administration.
David, looking at the surveys in particular, we're not saying there's anything wrong with the surveys. They're perfectly fine, and HRC has worked tirelessly to get the LGBTQ plus community more accepted in the workplace. The problem is that even though they're legal, they're going to raise your profile with an administration that has vilified trans people for sure. So I think that's our concern, that employers need to take a hard look and make some decisions about what their views about this are going to be.
The benefit of participating versus the risk, and that is the metrics that I think we're looking at all of this by.
Agreed.
So David, do you want to talk to us about to go?
Yeah, I was just going to say, let me just touch on this one, because it's kind of just another chapter, but it's the same storyline. Obviously, going back to that reminder that we had on Title VII, statutory quotas are per se unlawful under Title VII. That's been unlawful in this country since 1964. There's nothing new. Anyone that ran their diversity program so that a preference was treated or administered as a quota, same answer, per se unlawful. That is not controversial. And I know the administration would agree with that. I think everyone participating today would agree with that. What about other aspects that inform hiring and promotion? Aspirational goals and targets. Well, once again, as we say, the devil is a little bit in the detail. In concept, not necessarily bad, or bad meaning certainly not unlawful per se, but care must be taken, because if decisions are being made either on achieving, if it's a goal, it's a goal, or a target. That doesn't, if you administer it so that it is a preordained outcome or a required outcome, we're back up to the first bullet, it's a quota. And so again, this isn't a new admonition and concern point. It's something that I think all employers, well-counseled employers on this webinar fully understand. But I think that the takeaway and the reason it's potentially read is I anticipate the administration is going to be looking extremely closely at goals by race or sex and really bearing down on how those are administered. So a cautionary flag. They're not per se illegal, but they need to be careful. Now, the current buzzword, of course, is merit. I've never heard the word merit so much as I've heard in the last 2 weeks. Merit explains everything. If you have an organization where your leadership team says, we don't want to be in the risk zone at all. We want to comply with Title VII, and we want to really lower our risk in terms of being lit up or challenged by the new administration, then I would recalibrate so that you are focused almost exclusively on merit, what merit looks like, how you support merit, why decisions, whether it be hiring, promo decisions, comp decisions, all are driven off merit or other completely neutral factors. Those are points. Now, most organizations aren't going to be satisfied with that. I recognize that. But in terms of understanding the spectrum of risk, I think that's the lowest risk, but it's not very robust when it comes to more holistic employment practices. And that's why many organizations say, yeah, not enough. But there it is. It's not a safe harbor, but I think it's pretty green.
Absolutely. So moving on to some other DE&I programs or practices. So diverse slates, and there's been a lot of discussion about whether diverse slates are going to continue. This is red to yellow, and a few of us have discussed this. I'm more in the red category. Other members of this discussion think it can go a little bit more yellow, so we like to agree to disagree sometimes on these points. One of the things is you can have a diverse slate program done in a way that nobody is ever removed from the slate, and you simply expand that slate until you get diversity on there. But remember, you are then adding until you stop because you have added somebody of the desired diverse race or gender. So I still think you are making decisions in the diverse slate world based on race or gender or other protected class. I think that is really getting to a line that is going to be very problematic in this administration. I also know when boots are on the ground and you're adding people to this slate, and now your hiring manager has a slate of 10 to review or to interview, depending on where you put that slate in, the hiring manager is going to come back to you and say, get this down to 5. I'm not actually looking at interviewing 10. I'm going to interview 5. And then the diversity of the slate is actively looked at to determine what 5 get interviewed. So I think that in policy versus practice is very important when looking at these types of metrics, whether it's a diverse slate or other tools that you look at to push diverse candidates forward in the process. The Rooney Rule, I did go to Pitt, so I do love some Rooney here. But I do think where that is the requirement that you have that do in-person interviews based on of at least 2 of the minority representation. I think those days are numbered. I think that is an express decision based on race or gender. And I'm going to invite David to chime in here because we like to dispute this one.
Sure. No, I'm not even going to dispute that. I just would point out the Rooney Rule, which of course is from the owner of the Pittsburgh Steelers, Art Rooney, who put it in as a way, and it has been successful in the NFL of developing diversity. I just want to point out that the NFL, Roger Goodell, the commissioner, has indicated that the NFL is not backing off of DEI, and they have been the target. They were extremely the target of President Trump during his first term, referred to football players as SOBs and dun 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 on a variety of things. It was very raucous. So it's interesting that the NFL is leaning into this and is, as they say, unbowed and proud and sticking with the Rooney Rule. And so I think all of us, we may see sooner than later what the response is from the administration, because they've kind of thrown the gauntlet down. The NFL has. We'll see how that works out.
Yeah. Other actions or activity. Oh, we're going to go back a slide. Sorry. So looking at your outreach and recruitment efforts. So can you still do diversity-based outreach and recruitment? Yes, right? This is a yellow more towards green, but again, it's how are you doing it? Is it your sole focus of doing outreach and recruitment to, for example, if your only recruiting is to historical Black colleges and universities and no other college recruitment? That's probably going to be problematic. If you're doing a broad outreach that includes minority and female-based organization, that is going to be, I think, deemed to be fine. So it's looking at what those targeted community engagements are, what are those hiring fairs, and essentially making sure you're diverse in your outreach, that you're not just focusing on any protected class. Similarly, looking at this succession planning and high potentials, this is another place where sort of that diverse slate concept we have seen come into play. So we know many companies are looking at that succession planning, how to look at your internal talent to know who is ready to develop, and you spend resources on developing the high potentials, etc. If you have any sort of requirement that a certain percentage of your high potentials be of any particular race or gender, that's where your problems are going to come in. But still doing a high potential determination based on merit and skills and readiness to be elevated, that will be fine. Just making sure you don't have any representation numbers or requirements in those at that point is going to be very important to look at. The other thing, and this is also going to that measurement thing, are there leadership outcomes and engagement metrics that you have to meet in part of the succession planning or high potentials that is related to diversity numbers? Those are going to be somewhere the concern areas are. So making sure that they're open to all and advancement opportunity is not based on race or gender. You're going to probably be in pretty good shape. And then next we have a number of things that this is also the yellow green, and we could probably do a little bit of a whole session on that. So thinking about here, what data collection and analysis are you going to do? This is a big question. Everybody is talking about this right now. So again, back to the base level. What are you currently required to collect? Let's start there. That's your foundation. Applicant self-ID for veterans and disability. Still got to collect that applicant data. And then employee self-ID for race, ethnicity, gender, protected veteran, disability status. That you're still legally required to do. So then is what are the additional data collections that you want to continue to do beyond the federal required? So obviously, first step, what are your state requirements? That's a baseline on the legal. Then you need to think about anything that's not legally required. Ask yourself, what is the purpose of collecting the data? Then are you going to analyze the data? And if you're going to analyze the data, what are you going to do with those results? So if you are going to continue to collect applicant race and gender data, ask yourself, am I going to analyze it? if I analyze that data and I see a selection disparity, what am I going to do to remedy that? There are enough AAPs developed out there every year, and I am sure there's some of you out there who would run your adverse impact analyses on your selection data. You would see flags. Did you always follow up on those flags and determine what is the cause of that flag to make sure the disparity is not discrimination driven? You used to, kind of had the protection that you were doing some of that data collection under 11246. You're now not required to. So you just need to be very, very mindful on the why and how you're going to use that data. You also have to think about there's going to be what data do you collect, right? And so sex versus gender. Are you going to move into the realm of saying male, female, or are you going to start doing the non-binary data collection points? And how are you going to use that data? Similarly, with the data collection, are you going to advance to the new minority subgroups? I know, Nita, you have some thoughts on this point as well.
Yeah, I was just going to mention one thing that I was starting to think about today is we have forms that for those of us who are federal contractors, the self-ID forms, and in those for veterans and individuals with disabilities, we have forms. We're saying we're doing it for federal because we're a federal contractor, blah, blah, blah. If we're going to collect applicant data, we don't have a legal obligation to collect it. We're going to have a new form because we can't say we're doing it, at least not after April 21st, that we're doing it as a result of 11246.
Absolutely. And this also goes up to the data collection. Let's go back to sex versus gender for a minute. And we're talking about employee data, right? So we still have the EEO1 as of now. And so you are required to do your EEO1 report, which will just be male, female. They're not going to be expanding that to the broader categories. So if you're going to be asking your workforce to self-identify both sex and gender, any of the non-binary, how are you going to do that on a form to let them know one set of data is what we may be reporting to the government, the other set of data we're collecting, and the why? Why are we collecting it, and what are we going to do with that data? So there's a lot of questions to think through, and none of this should be done quickly. I think this needs to be done a thoughtful, metered way to make smart and informed decisions. And David, I know you wanted to chime in here as well.
I just one final thought, and I think this you're right. This discussion could occupy literally the entire hour on this point. I do think, though, that barrier analytics are extraordinarily helpful. I start with a strong presumption that they should be done. They need to be done with all the points that Liz has raised, thoughtfully, privileged, with an eye towards if I collect the data, what am I going to do with it? How do I use it in a way that is licit, et cetera? And it's a little bit of a different landscape without the 11246 obligations. That being said, I do think that barrier analytics, generally speaking, are an extremely useful tool that enable you to, in a preventive way, achieve compliance and not wait till a charge gets filed to realize you may have a potential broad-based or even systemic type problem. So I thought those points are, I mean, this is really meaty, challenging stuff, but I think it's so important to do. Because a lot of folks, I just want to call this out, because a lot of folks are like, well, do I still need to do all these analytics? Because 11246 was powered with a lot of analytics, not just data collection, but analytics. And notice that Liz didn't say just replicate what we did as a federal contractor. We're not using those groups that don't make any sense that were prescribed by the regulations. I mean, this is doing it in a way that you actually, to do a barrier analysis, you actually model what your employment appropriate groups are, how the decisions are made, and determine whether there are barriers. So I think this is a very useful discussion, really important point in the broad landscape.
So Nita, do you want to take us on to the next steps?
Sure. Well, we're getting close to the end of this, so we wanted to talk a little bit about our next steps and how to assess DEI programs to avoid some of this liability that we think is coming down the pike. So first and foremost, whatever you're going to do, privileged analysis needs to be completed by April 21st. And why is that? That's because that is the 90th day after the executive order was issued by President Trump, and they have given us 90 days grace to continue to comply with 11246. And we want to know where we stand before that is removed. David?
So public statements, we've touched on this. And again, we don't want you just to kind of lift up the rocks and look internally. We want you to think very broad at this point, cast the net broadly. Filings with the SEC, public statements, statements that the board has made, outward facing, a lot of social media. Social media absolutely should be scrubbed to see, I don't know how much latitude your executives have in your organization, et cetera, but let's be thoughtful and comprehensive in going through this, because you either need to own what's out there and be prepared to own it down the road, or if it needs to be, if you will, cleaned up. And we've done cleanup for plenty of clients. Little exuberance 12, 14 months ago is a different situation. Okay, that can be recalibrated. And there's a way of doing that thoughtfully, not with a big mea culpa, but just a clarification, an update. I mean, there are lots of strategies, but you have to first comprehensively understand what's there and then act accordingly.
You also need to, and as talked about before, is catalog and review all applicant and personnel processes that are going to affect the terms and conditions of employment. Get your arms around that. And this is a huge ask, and I understand that. So there are corporate policies, and then there may be divisional and individual groups. So even start with figuring out, how do I identify the key stakeholders who need to be part of the program so that we can understand what is happening throughout our organization. It is often going to be these smaller practices down a couple levels below that may end up getting the most noise, the squeakier wheels. So be very mindful and start doing that work as soon as possible if you're not already doing it.
Liz, I thought you did a great job talking about the ERGs, the employee resource groups, and the advancement programs. I don't know that I need to add to that, but that definitely needs to be reviewed in depth. And David?
Yeah, so we're going to kind of on that point end where we started, because this is all about Title VII at the end of the day. The key takeaway, though, determining whether something meets, I'll call it minimal standards. Does it comply with Title VII? That is a requirement, just like paying minimum wage is a requirement. But as we all know, in the marketplace, most of us do pay more than minimum wage for a variety of reasons. Well, most of us have pretty robust employment practices to attract and retain the best talent and to compete as effectively as possible and to get folks who are based on merit. But in this new environment, simply checking a box, did we minimally comply with Title VII? You should not stop there. And so please, even though we're recommending this be done on a privilege basis, it's more holistic as part of this risk assessment we've laid out. So, well, listen, guys, I think this has been a really great discussion, and I really want to thank both Liz and Nita. All of us are slightly sleep deprived this week, so I appreciate both of them making time for this really important discussion. I also want to point out we've been working very hard to help our clients and friends. We have a pretty robust resource page, and we keep adding to it almost daily. But check in, it's on our website, it's free. But we've got the executive orders. We have been doing podcasts on these subjects. We did a prior webinar that we've uploaded. It's all there to help you. We're going to put this webinar up there. Got client alerts. We have a lot of materials, and we're getting a lot of great feedback from clients that really appreciate that kind of one-stop shopping, because we know how busy you are in trying to get stuff explained to your leadership team. So that's our thought there. So we're going to keep working on this. We're going to do at least one more webinar. We've a couple times on this one mentioned about the False Claims Act. So next week we will get a notice out, but we are going to do a False Claims Act discussion That is a brand new topic for most labor and employment and compliance personnel in this space. So we want to at least orient folks from a basic understanding. This goes again, so you can help counsel your organization on risk assessment, and FCA, or False Claims Act, is such a key part of that now. It's now part of the legal landscape. So with that, I would just like to thank again Liz and Nita. Thank you both. You're terrific. And Sarah, thank you so much. We'll turn it back to you.
We would like to thank you for joining us this afternoon. If you have any further questions, please email us at info@fortneyscott.com. A recording of this webinar and a copy of the PowerPoint will also be available to all those who attended. This will be sent as soon as the webinar recording is available. And stay tuned for our next podcast and webinar.